Reactions have trailed the Federal High Court's ruling ordering the forfeiture of all assets belonging to Process and Industrial Development (P&ID) to Nigeria's government. This follows ongoing litigation between the federal government and Irish firm P&ID, which saw the conviction of two suspects said to be directors of the firm on allegations of fraudulent involvement in the 2010 contract. But the judgment is a far cry from the $9.6 billion judgment recently secured by P&ID Limited in a United Kingdom court against Nigeria.
It depends on what they're forfeiting. We don't even know what assets this company has in Nigeria. A lot of them are briefcase companies, shell companies. The promoters stay in hotels in Abuja, hang around the poolside, waiting for the next government official to sell his scam to. It's still going to be a far cry from the $9.6 billion awarded. I doubt if the assets in Nigeria will be up to $2 million. So it's a drop in the ocean. Essentially, what the court has just done is to make sure that they're not going to trade effectively in Nigeria anymore. They cannot carry business out. So
Recall the FCC commenced an investigation into the contract between both parties following a British court ruling that Nigeria owed the Irish firm about $9 billion for violating terms of the contract. However, there are concerns about how the forfeiture and conviction of these P&ID associates affect the payout negotiations. Can this be used as leverage to get a reduced payout sum?
It will be marginal. If they said they had spent like $40 million in Nigeria, and we can't even see what they've done. Maximum, that's if there are any assets at all, that's what we're seizing. But I doubt it. It smells like a shell company, like a scam. I don't see how that is going to form part of the negotiations.
The contract for gas supply and processing was signed by the administration of late President Umaru Yar'Adua and P&ID. The company was to build gas processing facilities around Calabar, Cross River State, and the government was to supply wet gas up to 400 million standard cubic feet per day. The agreement defined wet gas as associated gas removed during oil production, having a propane content of not less than 3.5% and a butane content of not less than 1.8 content, compressed and delivered via pipeline to the site. A three-member arbitration panel that reviewed the contract had ruled against Nigeria and ordered the government to pay the firm $6.6 billion as damages. A British court last month ruled against Nigeria's objection to the 2017 arbitration. The money with interest has now accumulated to about $9 billion, approximately 3.24 trillion naira, over one-third of Nigeria's 2019 budget. The agreement was designed to fail as key element necessary for its success was missing, with the impression of internal collaborators involved in the deal. It also calls to question the processes of awarding contracts in Nigeria.
Now, the P&ID matter that we lost, we played over it, glossed over it, and then it became solidified. Now we are running head-to-head, trying to bolt the staple to close the staple when the horse has bolted. Well, Nigeria must learn to do things at the right time. The law is all about timing. When issues are open in court, you have to follow it timeously and ensure that the integrity of the country is preserved. Because what we are looking at is not only the losses, the financial losses, we're also losing goodwill among investors.
The House of Representatives says it will investigate the circumstances that led to the $9.6 billion judgment and also invite the Attorney General of the Federation, Abubakar Malami, and the Minister of State for Petroleum, Timipre Silva, for interrogation. But will Thursday's ruling give Nigeria the needed bargaining chip in any negotiations with P&ID or in any related trial outside Nigeria? Rootstv Nigeria.